Civil Procedure Code Practice Questions Session 4. In this session, we will discuss the questions that may be asked in Judicial Services examination. We help the students in preparation of Judicial Services examination through WhatsApp. If you want to receive regular updates, please send us your mobile number through WhatsApp on 8199898985. Question number 76. Which of the following form the essential test of res judicata? Option A, matter in issue in the suit. Option B, subject matter and the object of the suit. Option C, the relief claimed in the suit. Option D, the cause of action on which the suit is based. Answer is option A. A is the answer. Matter in issue in the suit form the essential test of res judicata. Question number 77. The expression former suit in section 11 implies. Option A suit which has been decided prior to the suit in question. Option B, a suit which has been instituted prior to the suit in question. Option C, both A and B. Option D, none of the above. Answer is option A. The expression former suit in section 11 implies a suit which has been decided prior to the suit in question. Question number 78. The principle of res judicata applies. Option A, when the matter in former suit is directly and substantially in issue. Option B, when the matter in former suit is collaterally and incidentally in issue. Option C, when the matter in former suit is directly and collaterally in issue. Option D, when the matter in former suit is collaterally and substantially in issue. Answer is option A. The principle of res judicata applies when the matter in former suit is directly and substantially in issue. The doctrine of res judicata is conceived in the larger public interest. Which requires that all litigation must sooner than later comes to an end. The doctrine of res judicata is conceived in the larger public interest, which requires that all litigation must sooner than later come to an end. The principle is also founded on justice, equity, and good conscience, which requires that a party who has once succeeded on an issue should not be harassed by multiplicity of proceedings involving the same issue. Section 11 embodies the rule of conclusiveness and operates as a bar to try the same issue once again. The doctrine of res judicata is conceived in larger public interest, which requires that all litigation must sooner than later comes to an end. The principle is also founded on justice, equity, and good conscience, which require that a party who has once succeeded on an issue should not be harassed by multiplicity of proceedings involving the same issue. Section 11 embodies the rule of conclusiveness and operates as a bar to try the same issue once again. Conditions: it is not every matter decided in a former suit that will operate as res judicata in a subsequent suit. To constitute a matter as res judicata under section 11, the following conditions must be satisfied. First condition is matter directly and substantially in issue. Second condition, same parties. Third condition, same title. Fourth condition, competent court. Fifth condition, heard and finally decided. First condition, matter directly and substantially in issue. The matter directly and substantially in issue in the subsequent suit or issue must be the same matter which was directly and substantially in issue either actually or constructively in the former suit. Second condition, same parties. The former suit must have been a suit between the same parties or between parties under whom they or any of them claim. Third condition, same title. Such parties must have been litigating under the same title in the former suit. Fourth condition, competent court. The court which decided the former suit must be a competent court to try the subsequent suit or the suit in which such issue is subsequently raised. Fifth condition, heard and finally decided. The matter directly and substantially in issue in the subsequent suit must have been heard and finally decided by the court in the former suit. Question number 79. In which of the following cases the principle of res judicata will apply? Option A files a suit against B for declaration that he is entitled for certain lands as hereof see. The suit is dismissed. In a subsequent suit, he claims the same property on the ground of adverse possession. In this situation, the principle of res judicata will not apply. Option B, A sues B for possession of certain properties on the basis of sale deed in his favor. B impugns the deed as fictitious. The plea is upheld and suit is dismissed. A subsequent suit is filed for some other properties on the basis of the same sale deed. In this case, principle of res judicata will apply. A files an eviction petition against B, the tenant. On the ground of misuse of tenanted premises. During the eviction proceedings, before the rent controller, A and B enter into a compromise degree Subsequently, A files another eviction petition against B on the ground of bona fide requirement. In this situation, the principle of res judicata will not apply. Option D, none of the above. So answer is option B. Question number 80. A alleging that he is the adopted son of X sues B to recover certain property granted to him by X under a deed and forming part of X estate. The court finds that A is not the adopted son of X, but he is entitled to the property under the deed, and a decree is passed for A. The finding that A is not the adopted son of X. Option A. The finding that A is not adopted son of X will not operate as res judicata in the subsequent between A and B, in which the question of adoption is again put in issue. Option A is correct. The finding that A is not the adopted son of X will operate as res judicata in subsequent suit between A and B. Option B is not correct. The finding depends upon the court's discretion. Option C is also not correct. Option D, none of the above. So option D is not correct. Answer is option A. Question number 81. Res judicata affects. Option A, the parties to the suit. Option B, the previous, that is, persons claiming under the parties to the suit. Option C, the persons not expressly named as parties to the suit, that is, in a representative suit. Option D, all of the above. Answer is option D. Res judicata affects the parties to the suit. Res judicata affects the previous, that is, persons claiming under the parties to the suit. Res judicata affects the persons not expressly named as parties to the suit, that is, in a representative suit. Option D, all of the above. So answer is option D. Question number 82. Res judicata may operate between option A plaintiff and a defendant. Option B, co-plaintiffs. Option C, co-defendants. Option D, all of the above. Answer is option D. Res judicata may operate between a plaintiff and a defendant, between co-plaintiffs, between co-defendants. Question number 83. Which of the following is an essential condition for the application of the rule of res judicata between the co-plaintiffs oblique co-defendants? Option A, there must be a conflict of interest between the parties. Option B, it is necessary to decide that conflict in order to give relief and to determine the issue in the case. The conflict has been conclusively determined. Option C. The co-defendants were necessary or proper parties in the former suit. Option D. All of the above. Answer is option D. All conditions are essential for the application of the rule of res judicata between the co-plaintiffs, co-defendants. Question number 84. Which explanation to section 11 refer to cases in which decision in a suit may operate as res judicata against persons not expressly named as parties to the suit? Answer is option D. D is the answer. D is the answer. Explanation 6th to section 11. Question number 85. Where persons litigate bona fide in respect of a public right or of a private right claimed in common for themselves and others, all persons interested in such right shall, for the purposes of section 11, be deemed to claim under the persons so litigating. This is an example of constructive res judicata. Such type of situation, it is mentioned in explanation 6. Where persons litigate bona fide in respect of a public right or of a private right claimed in common for themselves and other, such type of suit is called representative suit. Conditions. The following conditions must be satisfied before a decision may operate as res judicata in representative suit under explanation 6. First condition is there must be a right claimed by one or more persons in common for themselves and others not expressly named in the suit. Second condition is the parties not expressly named in the suit must be interested in such right. Third condition is the litigation must have been conducted bona fide and on behalf of all parties interested. Fourth condition is if the suit is under Order 1, Rule 8, all conditions laid down therein must have been strictly complied with. Conditions: a right, there must be a right claimed by one or more persons in common for themselves and others not expressly named in the suit. Second condition, the parties not expressly named in the suit must be interested in such right. Third condition, the litigation must have been conducted bona fide and on the behalf of all parties interested. Fourth condition, if the suit is under Order 1, Rule 8, all conditions laid down therein must have been strictly complied with. It is only when the above conditions are satisfied that a decision may operate as a res judicata in the subsequent suit. Question number 86. When a party files a suit, he must bring the suit complete. He must include all the facts pertaining to that case and must claim all the reliefs that he is entitled to. Failure to do so would bar such a party from raising those pleas again. This is called constructive res judicata. Option A, constructive res judicata. Option B, res judicata. Option C, express res judicata. Option D, none of the above. Answer is option A. Question number 87. The rule of constructive res judicata is option A, a product of judicial interpretation. Option B, a rule of equity. Option C, contained expressly in the code. Option D, a part of Supreme Court rules. Answer is option C. C is the answer. The rule of constructive res judicata is contained expressly in the code. Answer is option C. Question number 88. The doctrine of constructive res judicata is not applicable. Option A, in the absence of adjudication between parties. Option B, when no finding was given to an issue in the previous suit. Option C, both A and B. Option D, none of the above. Answer is option C. The doctrine of constructive res judicata is not applicable in the absence of adjudication between parties. The doctrine of constructive res judicata is not applicable when no finding was given on an issue in the previous suit. Answer is option C. Question number 89. In which of the following cases the doctrine of constructive res judicata is not applicable? Option A, A sues B on a contract and obtains a decree. B afterwards sue for rescission of the contract on the ground that it did not fully represent the agreement between the parties. In this situation, res judicata is applicable. Option B, A sues B for possession of certain property, alleging that it has come to his share on partition of joint family property. B's contention that the partition has not taken place is upheld and the suit is dismissed. A subsequent suit was filed by A against B for partition of joint family property. In this situation, in this case, constructive res judicata is not applicable. Option C, A files a suit against B to recover money on promissory note. B contends that the promissory note was obtained from him by undue influence. The objection is overruled. The suit is decreed. B challenges the promissory note on the ground of coercion and fraud in a subsequent suit. In this situation, constructive res judicata is applicable. Option D, all of the above. So, in option B, the doctrine constructive res judicata is not applicable. So, answer is option B. Question number 90. the phrase litigating under the same title connotes? Option A, that the demand should have been of the same quality in the second suit as is in the first. Option B, that the parties must have litigated under the same title in the same capacity in the former suit. Answer is option B. B is the answer. Question number 91. Principle of res judicata applies to suits only. Option B, to execution proceedings. Option C, to arbitration proceedings. Option D, to suits as well as execution proceedings. Answer is option D. Principle of res judicata applies to suits as well as execution proceedings. Question number 92. A sues B for rent. B contends that C, not A is the landlord. A fails to prove his title and the suit is dismissed. A then sues B and C for a declaration of his title to the property. We have four options. Option A, the suit is not barred as the parties in both the suits were not the same. Option A is correct option. Option B, the suit is barred as the relief claimed is substantially the same in both the suits. Option C, the suit is barred as the parties in both the suits were the same. Option D, none of the above. Answer is option A. Question number 93. A suit brought by a person to recover possession from a stranger of mut property, claiming it as heir of the deceased Mahant. The suit is dismissed on his failure to produce the succession certificate. A second suit was filed by him as manager of the mut. Option A, the second suit will be barred by res judicata. Option B, the second suit will not be barred by res judicata. Option C, the second suit will be barred by res sub judice. Option D, none of the above. Answer is option B. B is the answer. The second suit will not be barred by res judicata. Question number 94. An essential condition for the application of res judicata is that the court which decided the former suit must have been a court competent to try the subsequent suit or the suit in which such issue is subsequently raised. Competency of the court relates to option A, pecuniary jurisdiction. Option B, jurisdiction as to subject matter. Option C, territorial jurisdiction. Option D, both A and B. Answer is competency of courts relates to pecuniary jurisdiction and jurisdiction as to subject matter. So answer is option D. Question number 95. Mark the correct statement. Option A. If finding of a criminal court does not bind the civil court. Option B. A revenue court decision on a question of title will bar a suit in the ordinary civil courts. Option A. Finding of a criminal court does not bind the civil court. Correct statement. Option B. A revenue court decision on a question of title will bar a suit in the ordinary civil courts. It is also correct statement. So answer is option C. Question number 96. Whether an issue heard and finally decided by a competent court of limited jurisdiction shall operate as res judicata in a subsequent suit that the aforesaid court was not competent to try. Option A, no. Option B, yes. Option C, answer would depend upon the nature of the issue. Answer is option B. Whether an issue heard and finally decided by a competent court of limited jurisdiction shall operate as a res judicata in a subsequent suit that the aforesaid court was not competent to try. Answer is B. Question number 97. The last condition for the application of res judicata is that matter directly and substantially in issue in the subsequent suit must have been heard and finally decided by the court of in the first suit, in which of the following cases a matter will be said to be have been finally decided. Option A. The decision in the former suit was on the merits. The former suit was disposed of ex parte. Option C. The former suit was dismissed for failure to produce evidence when time was allowed to do so. Option D. All of the above. Answer is option D. Option D is the answer. Question number 98. In which of the following cases a matter cannot be said to have been finally decided, thus res judicata will not apply? Option A. The former suit was dismissed by the trial court for want of jurisdiction. Option B. The former suit was dismissed for default of plaintiff appearance. Option C. The former suit was dismissed on the ground of non-joinder or misjoinder of parties. Option D. All of the above. Answer is option D. Option D is the answer. Question number 99. Mark the incorrect statement. Option A. The doctrine of res judicata as codified in section 11 CPC is exhaustive. This is incorrect statement. Option B, the plea of res judicata cannot be involved at a subsequent stage in the same proceeding but only in a separate subsequent proceeding. This is a correct statement. Option C, the plea of res judicata has to be specifically raised. This is also correct statement. Option D, the principle of res judicata is mandatory. This is also correct statement. So answer is option A. The doctrine of res judicata as codified in section 11 is exhaustive. This is incorrect statement. Question number 100. In a suit where the doctrine of res judicata applies, the suit is liable to be option A stayed, option B dismissed, option C may be stayed and may be dismissed, option D both A and C. In a suit where the doctrine of res judicata applies, the suit is liable to be dismissed. So answer is option B. We help the students in preparation of judicial services examination through WhatsApp. If you want to receive regular updates, please send us your mobile number through WhatsApp on 8199898985. Please feel free to contact us at legalbuddy@gmail.com. Thank you.